Mr. Sullivan, let's start with telling me a little bit about your career beginning with law school.
I went to Loyola Law School. I didn't have litigation in mind at all. But when I went to work at Jenner and Block, the position I was offered was working with Charlie O'Loughlin, who was a litigator. So that's what I did. There was a lawyer, Pren Marshall, and he encouraged me to join the Chicago Bar Association Defense of Prisoners Committee. At that time, the public defender of Cook County had 9 lawyers. They now have hundreds. And so the Defense of Prisoners Committee supplemented their work. There was just any indigent who said, I don't want the public defender. It permitted you to get into court and actually get up on your feet and try the case, which otherwise, both then and now, takes a long time for a young lawyer, particularly in civil cases, because the person that's hired is not the young lawyer, it's the older lawyer in any significant case. And most civil cases are settled, whereas many criminal cases go to trial. Sometimes I think the victims were the people we represented because we were not very talented. But it did give us exposure to the courtroom and jury trials, because it was almost all jury trials, and street crime, crime, robbery, murder, rape, whatever came along, that's what we did.
What do you think the importance of pro bono is in an attorney's life?
When I look back on my career and think about the important cases that I really remember, almost all of them are criminal. And if you put aside the work I did as U.S. attorney, virtually all of them are pro bono cases. I have trouble remembering all the civil cases I did and the pro bono work, like with the House Un-American Activities Committee, the Contract Buyers League. Some of those pro bono efforts, the work on the Capital Punishment Committee, that sort of thing, sticks with me and is more meaningful to me than the work I did for fees.
Can you point to one accomplishment that you're the most proud of?
I have taken it upon myself, just as a private citizen, to inquire into why policemen and prosecutors resist the idea of electronic recording of custodial interrogations. And when I first got into this, I was on the Governor's Commission on Capital Punishment. We recommended that all interrogations of homicide suspects be recorded. In 2003, Barack Obama, who was then a senator here, pushed it through as his project. We became the first state in the union to pass that. The prosecutors and the police resisted it as though they were all going to have to go get different jobs if that passed. There are now 11 states that have statutes. 5 Supreme Courts have rules that are statewide. And the whole thing is turned around. The law enforcement people now say it's a great idea, but we don't want to be told we have to do it. And that's the only thing I know of that I've done where I can say it actually made a difference. We're now moving to eyewitness identification reform, which is more important, really. That's where most of the mistaken convictions come from. Almost all lineups are not done by human beings, they're done with photos. In many of these cases, I believe the witness says, well, I think that may be the guy, but I thought he had a scar on his cheek, or that he had yellow hair, or that he had a beard. And the detectives are saying, well, that's okay. Or they might say, take another look at number 3. By the time they get to court, it's no longer, that may be the guy. That's the guy. If you videotape the procedure, you get the actual reaction of the witness at the time. Now, this may result in guilty people being released, But the purpose of trials is to get to the truth. Also to use blind administrators, or if you're in a small department that does not have that many officers, use blind methods so that they put the pictures into folders or on a screen and turn the screen around, assign numbers randomly, and have the witness looking without the policeman the administrator being able to see who they're looking at. So they can't hint, even subconsciously. I'm not saying that they're deliberately doing this.
Do you have any words of wisdom for lawyers?
This doesn't apply every day of your life, but in a career you will find times when you are being asked to deviate from your basic principles of justice, whatever they are. I think there's only two kinds of lawyers, one who stick with their principles and the others that bend. And I refuse to bend. When I first started practicing at Jenner & Block, I worked for one lawyer who was in litigation for 2 years. And he disputed most everything the other side wanted. Then I started working for Bert Jenner. And Bert Jenner would never start a conversation out with the lawyer about what he was going to talk about. How's your family? How you doing? How's your wife? What's happened to that daughter of yours? Getting along with people, not arguing with them, not picking fights. All of a sudden I saw this can be easy, that you can smooth this over if you just treat people decently and be friendly. There's a natural tendency, I think, on the part of a lot of young lawyers to want to be tough. And so they create a lot more problems than they should.
Jerry Sullivan said of you that you strongly believe that a lawyer has a duty to improve society.
I do think that lawyers have an obligation to engage in pro bono work for the underprivileged people in our society, of which there are many, and who need legal representation, not just in criminal cases. Most of it's not criminal at all. Most of it's in immigration cases, housing cases. When I was in the Contract Buyers League case for about a decade, helping these people, these African-American people who couldn't get mortgages because of discriminations. Those are the kinds of things that I think lawyers need to do.